This episode is brought to you by LifeLock. With Cybersecurity Awareness Month winding down, LifeLock wants to remind you to update your software. These updates will patch up security issues that identity thieves can exploit to gain access to your personal info. For comprehensive identity theft protection, there's LifeLock. LifeLock alerts you to more uses of your personal info and fixes issues that arise. Protect your identity today with a 30-day free trial at LifeLock.com/podcast.
Welcome back to Amicus. This is Slate's podcast about the courts and the law and the rule of law and democracy. And I guess now we also get to call it what Donald Trump's former chief of staff has called it, the prospect of slow rolling fascism. I'm Dahlia Lithwick. I cover those things for Slate. So this week, we really wanted to stick with our pre-election thesis of giving you news you can use, but we also wanted to put it into the Amicus framework that focuses in on the stakes of what might happen to the law, what it can be counted on to deter, but also how it can be weaponized in malevolent hands after the election is over. Because, please recall, the law is not an end in itself. It is just a tool. And if Project 2025 has taught us anything, it's that there is zero fear on the part of the next Trump administration of using whatever legal tools are available to achieve some truly chilling ends. So, we are going to be talking about the Alien Enemies Act of 1798. It is the last of the notorious Alien and Sedition Acts to remain on the books. And if Donald Trump gets his way, he has promised, very explicitly, that once elected, he will be dusting it off for purposes of his, quote, mass deportations of non-citizens. Now, it's easy to poo-poo the possibility of using a rarely invoked 18th century law that specifically provides that it can only be used when there is a, quote, declared war between the United States and any foreign nation or government, in order to deploy the military on U.S. soil to seize, detain, and deport immigrants. And yet Trump has very specifically pledged to do precisely this. So here he is, speaking variously at rallies in Colorado, California, and Arizona.
I will rescue California and every town across America that's been invaded and conquered. And we will put these vicious and bloodthirsty criminals in jail or kick them the hell out of the country, which is number one. We will send elite squads of ICE, Border Patrol, and federal law enforcement officers to hunt down, arrest, and deport every last illegal alien gang member until there is not a single one left in this country. I'm announcing today that upon taking office, we will have an Operation Aurora at the federal level to expedite the removals of these savage gangs, and I will invoke the Alien Enemies Act of 1798. Think of that. The Alien Enemies Act of 1798. This was put there 1798. That's a long time ago, right? Those were the old days when they had tough politicians. They have to go back that long. Think of that, 1798. Oh, it's a powerful act. You couldn't pass something like that today. Today we're politically correct. 1798. That's when we had real politicians that said we're not going to play games.
We've talked before on the show about the 1873 Comstock Act and how it was used by one trial court to take mifepristone off the market. We've discussed the ways in which the Arizona Supreme Court decided last spring to enforce a long, dormant 1864 abortion ban in that state. So it seems like it's high time to take the promise to use the Alien Enemies Act of 1798 very seriously for purposes of what Trump's team wants to do in something they call Operation Aurora. Joining us to understand whether the Alien Enemies Act is a dead letter of the past or a harbinger of what comes next is Katherine Yon Ebright, counsel in the Brennan Center's Liberty and National Security Program, where she focuses on war powers and the constitutional separation of powers. Yon Ebright previously served as a fellow at the Public International Law and Policy Group. And Katherine, I am so sorry to make you listen to that montage right out the chute. Your face on that Zoom was just, well, the picture painted 1,000 words, at least for me. So welcome to Amicus, and apologies for starting you off right there.
Thanks for having me, Dahlia. It's great to speak on this subject because it's actually a subject that I've been researching for around a year now, a little bit longer than that, because the actual promise to use the Alien Enemies Act for mass deportations was first raised by Trump, and even before that, by anti-immigration groups in 2023 in the late summer, early fall. And so when that promise was first made, I thought, okay, this is a wartime authority. And I think people aren't taking it seriously that that kind of wartime authority could be misappropriated into our relative peacetime context.
Maybe before we even get to the history and the scope and the constitutionality of the Alien Enemies Act, let's talk about why we care. And as you say, the media really only started to pay attention to this old statute after Donald Trump made those remarks in Aurora, Colorado, which, by the way, we should say those remarks were totally refuted by local authorities, the same way the scapegoating of Haitians in Springfield, Ohio, had been refuted by local authorities, right? The police have been very clear, I think, in Aurora, that there just aren't roaming bands of Venezuelan gangs taking over the entire city. But this was never really about what was happening truthfully in Aurora, any more than the claims in Springfield about migrants eating your pets were really happening in Springfield. So I would love to just start by having you connect for us the fact that you can just say, look, everything he's saying is not true, and the local authorities agree it's not true, so why are we even taking this seriously? Why do we have to think seriously about the Alien Enemies Act, even when the underlying story that Trump is telling is completely false?
I think the thing to do, and, as a 501c3 employee, the thing that I must do is contextualize this within the letter of the law. What we've seen in the past 2 years, really more than 2 years, going back even before people were talking about the Alien Enemies Act on the 2024 election campaign trail, you had in Texas, Governor Greg Abbott trying to take the reins on immigration enforcement, which, as your listeners may know, is an explicitly federal prerogative. It's not something that the states can do unless the Congress asks for the states to be involved, or the Attorney General asks for the states to be involved in immigration enforcement. And with what Texas calls Operation Lone Star, Texas began taking these steps that were very close to border management. For instance, putting a concertina wire-laced buoy in the Rio Grande, and also passing a law called SB4, which is more or less immigration enforcement, not quite issuing removal orders under Texas state law, but something quite adjacent to that. So Texas started taking these steps that looked a lot like we're encroaching on federal prerogatives. And it's said that the reason that they could do that was because they had been, quote unquote, actually invaded, and that migration, cartel activity was a, quote unquote, invasion. There is a part of the Constitution in Article 1, Section 10 that says that the states, can't, quote, engage in war unless they are actually invaded. And what Texas was doing, what Governor Abbott was doing, was saying, look, this immigration enforcement is actually our way of engaging in war, because building that concertina wire, that's our protection against this quote-unquote invasion. And so this rhetorical invasion has been really amplified to obfuscate where, trumped up political rhetoric ends and where the law begins and ends, and to sort of conflate the two, and then I think lead to some measure of confusion or frankly, bad faith action by politicians and later by the courts. And so what we've seen in the context of what's going on in Texas is there actually are some judges on the Fifth Circuit who are trying to say, yes, migration is an invasion. Texas can claim that it's been actually invaded and thus can, quote unquote, engage in war by managing the border and expelling people from the country, even though those are under long-standing Supreme Court jurisprudence, federal roles, not state roles. And so, we just took this detour into what's happening in Texas. How does that relate to the Alien Enemies Act. As you said in the intro, the Alien Enemies Act can be used in times of quote-unquote declared war. And that's true. That is the primary use case for this law. But the language is actually a little bit broader than that. The statute allows the president to invoke the law not only in times of explicitly declared war with a congressional declaration of war, but also in times of presidentially identified invasion or predatory incursion. And so, here we have that same word that we've already seen the weaponization of it in the constitutional context in the past 2 years, pioneered by Greg Abbott and Ken Paxton in Texas. But now we're seeing it pioneered by others, including the former president, in the context of the Alien Enemies Act. When we have this rhetoric about gangs from Venezuela are invaders, they have conquered Aurora, or Mexican cartels are invaders, they've conquered cities in California, right? It is not necessarily bounded by how the mayors in those municipalities view the facts. It's much more, I think, driven by this desire to conflate the rhetoric and the legal meaning. That's what I think is happening here. And that's one of the things that I think makes this law, combined with the rhetoric, so concerning.
You're saying something super interesting, Katherine, that I think is always useful, which is there's a tendency to think, the following parade of horribles will only happen depending on the outcome of the presidential election. But it's really important that what you're flagging is this is already happening in Texas. This language of invasion is being invoked, and it's being invoked in ways that are getting, in some cases, like a very warm reception at the court. And this kind of binary of thinking that, these things will only unfold depending on who wins the election sort of elides the fact they are already unfolding all around us. And this language of invasion is being deployed for deliberate legal purposes. I think before we go too much further, I would love for you to walk us through the history of the Alien and Sedition Acts, 1798. I don't know about you, but I learned in law school that they were bad, passed by John Adams when the United States was on the brink of war with France. Can you just walk us through what was happening when the Alien and Sedition Acts were passed, and what was the anxiety that sort of animates the four laws of which one remains today?
Sure, of course. And I'll say I have actually the foggiest recollection of the Alien and Sedition Acts being bad from high school. And so I think this is, not just a thing that lawyers are aware existed in our history as sort of a negative precedent, negative action by the early American government, but it's generally something where you scratch your head, you're like, I've heard of that before, and it's not good. What you don't hear often is that one of those four laws is still on the books, and that, of course, is the Alien Enemies Act. But let's take a moment to go back, as some may want us to do, to 1798. That is the quasi-war with France. It is an undeclared war. That is an entirely naval conflict. History here, we owed some debts to France over the Revolutionary War, and we decided we weren't going to pay them back. Not exactly the best on our part, but it is what it is. It's our history. And so the French started seizing U.S. merchant ships. We wanted, of course, to defend our merchant ships. We end up in this conflict. The Congress is very anxious about the potential for a major conflict with a major European power. We just got out of one of those. We're pretty fragile, and we don't want to get into another. And so they pass these four laws, which they think will help secure the country in this wartime context, and particularly if that wartime context escalates. I think people are generally familiar with the Sedition Act, criminalizes certain forms of criticism of the government, pretty broad law, immediate negative reaction with respect to First Amendment principles, right? Freedom of speech, freedom of press. For our purposes, though, the, of course, most relevant law is the Alien Enemies Act. And then the second most relevant law is something called the Alien Friends Act. The Alien Friends Act, heavily criticized in its time as well, because what it allowed the president to do, even before there was a ground war, even before there was a declared war, was it allowed the president to scoop up immigrants that the president, quote unquote, deemed dangerous, believed were dangerous, and then deport them summarily. So, no trial, no hearing. That was the Alien Friends Act. And there was immediate pushback, even though this law passed, but immediate pushback saying that this was a diminution of the due process owed to immigrants. And also that this law violated the separation of powers insofar as it basically allowed the president to decide what kind of conduct would lead to a very serious consequence for immigrants. It didn't say the Congress must enact subsequent legislation deeming what dangerous means. And if someone does something that makes them dangerous, according to Congress, then the president can deport them. No, it was entirely the president decides. And that was something that drew backlash. There was a sunset provision in the Alien Friends Act. And so in 1801, Congress actually allowed that law to lapse. Then we get to the Alien Enemies Act, which was the wartime authority, which was if this quasi-war with France escalates into a ground war or becomes a declared war pursuant to a congressional declaration of war, then this kicks in. And because the immigrants from, or people of the foreign belligerent, which in this case would be France, would under the 1798 law of war or law of nations be considered indistinguishable from quote unquote prisoners of war. Those immigrants could be regulated. They could be summarily detained, summarily deported by the president. And so it's open season on anyone from the foreign belligerent who is not a U.S. citizen themselves. That is the history, I guess, that undergirds this. It's a very different time by way of what does the law of war say. It was also, I think it's really worth noting, a very different time in terms of what U.S. law said. Let's start at, we had a nascent criminal law. There were very, very few federal offenses because our country's been around for, a decade. There was no immigration law whatsoever. There were no federal law enforcement agencies. There were no federal intelligence agencies. And so the idea of giving the president this very broad tool in wartime, it may offend our modern sensibilities, but at that time, the president had very little to work with. And so maybe it wasn't the craziest thing at the time to say, we're going to give this sweeping power to the president. Today, of course, we're living in a world where we have really well-established notions of due process. We have the Equal Protection Clause and the way that that's then informed the Fifth Amendment. And those were all things that were absent in the 1790s. We also, of course, have hundreds of thousands, truly hundreds of thousands of officers working to protect the Homeland Security and develop federal intelligence. We have so much criminal and immigration law, too.
We are going to take a short break.
Planned Parenthood Federation of America exists so that all people can get access to the sexual and reproductive care and education they need to make informed decisions about their health. More than 2 million patients a year rely on the services Planned Parenthood health centers provide, like STI testing and treatment, birth control, gender-affirming care, abortion, cancer screenings, and so much more. Right now, all across the country, reproductive health care and rights are under attack from public officials who are out of step with the will of the vast majority of Americans. The constitutional right to abortion, control of our bodies, and the health care we need has been stolen from us. And now politicians in 47 states, yes, 47, have introduced bills that would block people from getting the sexual and reproductive care they need. Planned Parenthood knows that equitable access to health care, including safe, legal abortion, is a human right. Right now, Planned Parenthood needs your help to protect access to health care. Donate today by visiting PlannedParenthood.org/protect.
Oh, it's such a clutch off-season pickup, Dave.
I was worried we'd bring back the same team.
I meant those blackout motorized shades.
Blinds.com made it crazy affordable to replace our old blinds.
Hard to install?
No, it's easy. I installed these and then got some for my mom. She talked to a design consultant for free and scheduled a professional measure and install.
Hall of Fame son.
They're the #1 online retailer of custom window coverings in the world.
Blinds.com is the GOAT.
Shop Blinds.com right now and get up to 45% off select styles. Rules and restrictions may apply.
More now with Katherine Yon Ebright from the Brennan Center on whether the Alien Enemies Act could really be used to round up and deport millions of people. Katherine, you flicked at this early on in our conversation, but it feels to me as though for purposes of our listeners sort of understanding the term of art, so let's stipulate the Alien Enemies Act is the only part of the Alien and Sedition Acts that isn't either repealed or allowed to expire. And the term of art that we are supposed to be kind of working through now, as you said, is what is an invasion? What is a predatory incursion? Can you just help me understand what it is that was anticipated? I want to throw the bone to originalism and to understand what they thought they were controlling for with that language.
In that context, right, you can imagine Congress is not in session. We don't have email. We maybe ride on horses to get to the Capitol. What happens if France decides to take this naval war and turn it into a ground war and Congress is not in session? There is an invasion. There is an armed attack on United States territory. That's the kind of scenario that they're contemplating. And, there is a historical, constitutional analog for that, right? In the Constitutional Convention, they write up the declare war clause and says Congress gets to declare war. Initially, they had drafted Congress gets to make war, but they edited that to be a declare war because they wanted the president to have a self-defense power in the event that, again, Congress isn't in session, but we come under some sort of attack. And so it's not shocking that the lawmakers include that language or presidentially proclaimed invasion or predatory incursion in acknowledgement that there will be circumstances or could be circumstances in which we end up in a conflict, but there is not yet a congressional declaration of war. And how do we know that invasion and predatory incursion are explicitly referring to acts of war instead of something totally rhetorical? Well, there are other parts of the law that refer to hostility or hostilities. Seems pretty probative. Also, invasion and predatory incursion are terms that appear right next to the term declared war. So it would be a little bit ridiculous to say that you either need a declared war or you need something totally rhetorical that is not an act of war at all. That's a way discordant lower threshold. That's just not how people write statutes. And that's also something that is a canon of statutory interpretation, that you're going to try to interpret those words to be parsimonious or similar in quantum. So that's just the text. But then also going to the negotiation history, constantly we see the lawmakers talking about the law of war and how the law of war allows you to treat quote unquote enemy aliens. Hate saying that, but quote unquote enemy aliens as prisoners of war. And this law is not cognizable outside of that context. And we saw that tremendous backlash to the Alien Friends Act, right? Which is this peacetime authority for doing part of what you can do under the Alien Enemies Act, right? Just the summary deportations. You can't actually do internment or detentions under the Alien Friends Act. Just by comparing the responses between the Alien Friends Act and the Alien Enemies Act, you can understand that one of them was relatively uncontroversial at the time because it was thought of as only in the context of this serious conflict that involves a ground incursion into U.S. territory or, again, a congressionally declared war.
Can you just talk about the 3 times because it's only, of course, been deployed 3 times. You would think that if the president has such robust deportation powers, this would be used all the time. It's a pretty narrow set of circumstances in which we actually see it used throughout American history.
Yeah, so the first time that we see this used is the War of 1812. The historical record, I'll admit, is not so robust on how exactly it was used, how thorough the enforcement was under it. One thing that happened was the day that there was the declaration of war, this law was invoked. And then the president made a proclamation with regulations that said, if you are a British subject, you cannot live within 40 miles of the coast. Next time that this is invoked is the same day that Congress declares war in World War I, also a major conflict. And then after that is the first and only time that this law was invoked in response to an invasion, and that is World War II with Pearl Harbor. And so the only time that this law has ever been invoked based on an invasion or a threatened potential predatory incursion was first against Japan vis-a-vis Pearl Harbor, which FDR recognized as a quote-unquote invasion under the law, and he invoked that law before Congress had come back into session to declare war. And then the following day, so December 8, 1941, he invokes the Alien Enemies Act against Germany and Italy, saying that they are allied with Japan in World War II, and that because we've just suffered this, really horrendous attack on Pearl Harbor, as well as other U.S. holdings in the Pacific, that we could reasonably anticipate an invasion or predatory incursion by Italy and Germany. What we have is a pretty robust record on how this law was used in World War I and World War II. And the answer is internment. It was used for internment. In World War I, we don't, I think in grade school learn so much about German internment or Austro-Hungarian internment, but thousands of people put into these detention facilities, often military bases like Fort Oglethorpe in Georgia, for infractions of rules and regulations that had been put forward along the lines of you have to register with the federal government, and if you move, you have to update your registration. And so really nothing that's probative of disloyalty or some sort of danger, espionage, or sabotage that's going to undermine the war effort, but, thousands of people, internment camps. And then we are more familiar with the story, or some of the story, of World War II internments. This law was the beginning of Japanese internment. So again, invoked the same day as Pearl Harbor vis-a-vis Japan, and over 15,000 individuals, non-citizens of Japanese descent, are put into internment camps. Another 15,000 individuals, non-citizens of German and Italian descent, are put into internment camps. Right now in this moment, we're talking about the potential of the Alien Enemies Act to be used for deportation. We're also, now talking about internment, and so the use of the law for detentions. But one of the things that's quite shocking about the law is the ability of the president to issue these very broad-reaching regulations, granular regulations of non-citizens' lives if they hail from a foreign belligerent, on penalty of detention or deportation. And so without, any criminal statute, any new legislation from the Congress, the president gets to decide. If you are an Italian immigrant and you own a radio, if you are a German immigrant and you take a plane, if you are a Japanese immigrant and you're working in a particular kind of factory, you could be detained. You could be interned. And the enforcement, at least in World War II, was really questionable. There was a catch-all provision in the regulations, wartime regulations, that said, or if the president deems you dangerous. Where have we heard that before? We heard that in the context of the Alien Friends Act. And even in the 1700s, we knew that was, the president has too much authority. Does that actually mean anything? And so you saw Japanese immigrants being detained for things like sending a model plane, like a toy plane, to their son in Japan. And that means that you are a dangerous, quote-unquote, enemy alien who should be interned.
Katherine, you've written that, quote, because the Alien and Enemies Act does not require the president to show any misconduct or threat posed by targeted non-citizens, the law does not afford non-citizens an opportunity to present evidence of their loyalty to the United States. And I think this is so essential. It kind of goes to the, kinds of examples you're giving us of who could be subject to detention, who could be subject even to deportation. Can you just talk about even, when non-citizens have brought habeas cases, how limited their rights really are in this context?
Yeah. So I guess I want to say one thing first, which is in World Wars I and II, where we have that record, there certainly was discrimination against the groups that were targeted. But it's not like President Wilson or FDR and later Harry S. Truman were out there thinking, like, how can I persecute groups? Their thought was, what are things that maybe make me a little bit uncomfortable about the national security? And I'm going to promulgate regulations under the Alien Enemies Act that are targeted toward saying, like, if you're an immigrant, you can't have firearms. If you're an immigrant from one of those countries, you can't fly on a plane. Or, a little bit more preposterously in World War I, if you're an immigrant from Germany or Austro-Hungary, you can't live in D.C., period, even if you've lived there for the vast majority of your life. So get out. These are all limited regulations relative to the full scope of what the president can actually do under the law. The law does not require the president to say anything more limited than if you are found present in U.S. territory and you are the native citizen, denizen, or subject of the foreign belligerent, that by virtue just of your identity makes you targetable, makes you detainable or deportable. And so when I say that the law does not require any showing, any wrongdoing, unlawful presence, that is in reference to the full scope of the law. And the law has never been applied at that full scope. There were, in World Wars I and II, some efforts taken, like there were hearing boards in World War II, for instance. They were very biased. There was no legal representation. When people brought habeas petitions challenging their internment in World Wars I, and especially in World War II, when I think our, judicial identity was a little bit more established, what you saw the court saying is the president is entirely entitled to promulgate these regulations that are actually narrower than the full scope of the law. And nowhere in the law does it say that when the president tries to target you, you're entitled to a hearing. And so who are we to judge, right? Like, this is narrower than the authority of the law, and the law doesn't say you get to have that hearing, that there's some sort of standard of proof. And so those habeas petitions challenging the basis for the internment failed. The only habeas petitions that succeeded were ones where people were saying, actually, I naturalized, or actually, I have no connection to Germany, I'm French. Other than that, you would not have succeeded. Hopefully things would be different today.
So the folks who are chewing over this question you've been chewing over, as you said, for almost a year, of whether this could be exploited in some fashion to do either mass detentions or mass deportations as promised, there tends to be, I think, in the legal commentariat, a pretty knee-jerk, this could never stand, it's not an invasion, there's no declared war, whatever, as we went through the plain terms of the statute, it just couldn't happen, could never happen. And I want you to just parse for us, if you would, there's sort of two versions of that. One, I think, is your anxiety that, well, it couldn't happen until it could, right? I mean, that feels like it's shot through your work. But I think that there is this other anxiety that you've written about, which is that there's a long history and still a pretty deep history of treating this as a political question that is non-justiciable. In other words, the idea that the court wouldn't do the thing the court might just do, which is just say, yeah, this is for the political branches. That's a very real concern, regardless of the plain terms of the statute.
Yeah, so for centuries, like literally centuries, the courts have identified certain sensitive foreign policy and national security questions as really questions that are out of the realm of what the court should be engaged on, right? There's no judicially manageable standard for figuring out, like, what exactly is a foreign nation or government, which is one of the prerequisites for invoking the law, right? The invasion or the predatory incursion has to be perpetrated by a foreign nation or government. And the courts have said that's a political question. Like, that's not for us to decide. That's the president's decision. And then we've seen, since the 1990s, the courts really taking a back seat as well on the question of what is an invasion. Even before the 1990s, after the 1973 War Powers Resolution was passed, which allowed the Congress to force the president to withdraw from unauthorized hostilities, quote unquote hostilities, the court said, what are hostilities? That's not really our business to decide. Maybe if it gets to the threshold of like the Vietnam War, then we could say that those are hostilities. But things below that very, very clear threshold, that's, not our job. And so 1990s, you have a series of court cases brought typically by Republican governors that said that Article 4 of the Constitution, which guarantees not only a Republican government, but also the protection of states against invasion, these governors argued in court that migration was an invasion. And, there were some courts that said that doesn't seem right on the merits, but all of the courts that ever received that kind of claim dismissed the claim not because it was wrong on the merits, but instead because whether or not an invasion existed was a political question that was outside of the scope of what they could decide. And so they said, we're beholden to the decisions of the political branches, the president and the Congress, on this kind of issue. And then, of course, fast forward to today and what's happening in the Fifth Circuit and in Texas, you have a debate raging in some of these cases about whether Texas has been, quote unquote, actually invaded, on whether the courts can even look at the merits of Texas's claim. And so there are some judges, and we've seen people appointed by Democrats, people appointed by Republicans who have been sympathetic to the idea that, this is a political question and the courts have no business wading into the political thicket here. And I guess one last thing that I'll flag is that actually when Texas first started making that argument in the first case that DOJ sued it under, DOJ itself had argued that whether or not there was an invasion was a political question. And they said that knocks out of the case Texas's defense. DOJ has since, come around and realized that, maybe we should actually contest on the merits. We should ask the courts to reject on the merits this migration as invasion claim. And so I really appreciate that shift in DOJ's tactics here, because I think it is very important to actually get this question addressed on the merits. And my concern for the Alien Enemies Act, but also for the Fifth Circuit litigation, is that even when there is clearly no military invasion, there is no armed attack of the kind that's necessary to trigger this language, whether in the Constitution or in the Alien Enemies Act, the courts will say, not our business, not our ability to make that kind of judgment. In the report that I wrote on the Alien Enemies Act and some of the complementing materials, I discuss a potential backstop to the political question doctrine. Unfortunately, it's not a backstop that's ever been meaningfully tested. So in the 1960s, in a case called Baker v. Carr, the Supreme Court formalized the political question doctrine. So they had these hundreds of years of precedents of the courts sort of stepping back and saying, we're not going to second guess the president. We're not going to second guess the Congress. But they had never really formalized and named that doctrine. But Baker v. Carr does. And there is this paragraph in Baker v. Carr that says, okay, we understand that we're saying for the most part, we're not going to wade into the political thicket. But sometimes there will be a, quote, obvious mistake or, quote, manifestly unauthorized exercise of power. And we obviously can't turn a blind eye to that. We have to correct that. But, you look at the intervening 60 years of history, how many times have the courts actually relied on this supposed obvious mistake, manifestly unauthorized backstop? And the answer is 0. And so that's something that gives me a lot of concern for where we may be headed if there is a pretextual and abusive invocation of the Alien Enemies Act.
Can we just clear up one thing? Because I think we've had some slippage even in this conversation. The Alien Enemies Act applies to migrants from the relevant countries who've not been, quote unquote, naturalized. So that's going to include legal migrants, even permanent resident green card holders, right? So if a forthcoming Trump administration was able to use it, it could certainly be deployed against legal immigrants as much as they want it to be. Right. And I think that Trump and his allies have made pretty clear that they want to go after legal migration as much as they want to go after what they would call illegal migration, correct?
I think it's a little bit unclear the precise scope in how Trump would want to use this law. So who exactly would be targeted under it? A bit of a question mark at this precise moment. But it is noteworthy that they are talking about this law with this tremendous scope that does, as you said, cover people who are completely lawfully present. It covers permanent residents, it covers visa holders, it covers refugees and asylum seekers, and of course, also undocumented individuals. And so there are parts of conventional immigration law that provide for the expedited removal or summary deportation of certain individuals who are here and undocumented. In the first Trump administration, there were some efforts to expand those expedited removal provisions to their broadest reach and then use them against undocumented individuals in the interior. But now we are talking about a law that can be used against anyone who is an unnaturalized or non-citizen from a quote-unquote foreign belligerent. And we're talking about potentially declaring Venezuela and Mexico foreign belligerents, or maybe segments of Venezuela and Mexico as foreign belligerents. And so I think it really does make you wonder or pause, why are we turning to such a broad authority if all we want to do is target people who, could be subject to expedited removal?
Let's pause now to hear from some of our great sponsors.
I said to Roger, the last thing you are fair and balanced. That should have been my slogan.
When the Fox News Channel first went on the air, it promised to change television.
Few broadcasts take any chances these days, and most are very politically correct. Well, we're going to be different.
It's going to be kick-ass, and I want to be part of it.
I'm Josh Levine. In this season of Slow Burn, we'll look at the moment in the early 2000s when Fox News became a political and cultural force.
I'm okay with wearing an American flag. And if you're not, I think you need to examine who you are.
You'll hear from Fox insiders, many who've never spoken out before.
I was not told about that beforehand, for good reason. I wouldn't have gone along with it.
And you'll hear from the activists and comedians who tried to stop it.
He said, "You're being sued by Fox." I went, "Really? That's fabulous."
Slow Burn Season 10, The Rise of Fox News. Hear the entire season now, wherever you listen.
Let's return now to my conversation with Katherine Yon Ebright on the dangers of the Alien Enemies Act in the hands of Donald Trump. So Speaker of the House Mike Johnson has said that his first priority for January would be deporting 4.5 million people that he says have already committed crimes. And no, I don't know where that number comes from. And what he says is, quote, they're in the system now for shoplifting or whatever it is, or having done things that are untoward and unlawful, end quote. And folks like Aaron Reichlin-Melnick from the American Immigration Council say that what it would require to build out the apparatus to start to surveil and apprehend and detain and deport that number of people would more or less require turning the United States into a police state. That's kind of the fear, right? When you hear candidate Trump talking about deploying, every ICE agent and every police officer and the entire machinery and police machinery of the state to do this thing that they may say is just directed at gang members and criminals, but apparently is going to scoop up 4.5 million people. The fear is the apparatus in some sense, right?
I think there may be some intention or desire to have people self-deport, but yes, the logistics of this would certainly be tremendous. One potential thing that makes the Alien Enemies Act a desirable tool here, given some of the logistical challenges of managing that kind of mass deportation, is that this is also a detention authority. And so there's been some talk about migrant camps, putting people into militarized camps, which is just, horrific and very much like evokes the same sentiment or visuals as literal internment from World War II or World War I. And it's somewhat unclear, like, what authority would you have to detain individuals who are not subject to an immigration removal order, individuals who, are not being held pursuant to a criminal conviction? And the answer is potentially the Alien Enemies Act. If you want to put up these camps, that is a thing that this law conceivably could cover. Another thing on the logistics is, how does the Alien Enemies Act complement with other outdated and dangerous authorities? I have a colleague who works on something called the Posse Comitatus Act and the Insurrection Act, both of which are relevant to the potential that the military could end up involved in some of this immigration enforcement. It would be a tremendous logistical undertaking. The ways to do that logistical undertaking are also things that I think are very concerning.
So just to finish, I don't want to give Mike Johnson and his hopes and dreams the very last word. I want to give your hopes and dreams the very last word, but I think you've just more or less landed on the place that, when I worry about this, I worry about kind of defunct acts, not just the Alien Enemies Act, but, your colleague Mike Waldman at Brennan says we should also be repealing the Insurrection Act and we should also be repealing the National Emergencies Act. Like every single one of these, as you say, Posse Comitatus, there's so many things that can be used in bad faith to bad ends. But are we talking about repealing them just out of fear that, someone malintentioned in an upcoming Trump administration is going to abuse them? Or is there something bigger that is kind of driving your sense that we have to not leave all these loaded guns laying around on the constitutional table?
I'll let my colleague at perhaps a later date speak on the Insurrection Act and some of the reform proposals that the Brennan Center has there. But with respect to the Alien Enemies Act, explicitly and completely and totally endorsed repealing this law. And the concerns do, in fact, extend well beyond just the potential of an abusive president pretextually invoking it for, mass deportations as a workaround of conventional immigration law. Right? Like something that people outside of national security circles, potentially people outside of the Beltway, maybe don't hear so much about is the potential for a major conflict with China. That is something that is constantly on the minds of people in the Beltway and national security circles. And often the way that this is talked about is not if there is World War III with China, but rather when there is World War III with China. And a proposal that I have heard come up in the context of those conversations is what about using the Alien Enemies Act to intern people of Chinese descent? And that is just such a horrific proposition that it is something that if we should ever contemplate mass internment again, like, have we learned nothing from our own history? And so it's, I think, really profoundly important to get this law off the books, not only to prevent abuse, but to prevent an actual intended use of this law that is in the pattern of how it was used in World Wars I and II. Thankfully, we have some lawmakers who have proposed legislation to do a clean repeal of the Alien Enemies Act. In the House, we have Ilhan Omar, and in the Senate, we have Senator Mazie Hirono. They have introduced a bill called Neighbors, Not Enemies. And that is just a flat, clean repeal bill. One thing, too, though, that I'm now working with advocates to do and have been in talks with various Hill offices about is potentially in parallel to Neighbors Not Enemies, or potentially as an amendment to Neighbors Not Enemies, adding some apologies for the World War II era internments that have not yet been acknowledged by the federal government, or not sufficiently acknowledged by the federal government. You know, there was an apology regime and reparations for Japanese internment, and that covered not only people who were U.S. citizens of Japanese descent, but also non-citizens of Japanese descent who were interned under the Alien Enemies Act. In 2000, Congress passed an apology to Italian immigrants who had been interned and regulated under the Alien Enemies Act. There has never been federal recognition of the wrongs that were done to German immigrants, and that's a category that includes Jewish refugees who had been born in Germany, some of whom we put into internment camps, on the theory that categorically excluding refugees, Jewish refugees, from the scope of Alien Enemies Act regulation could allow individuals to use their refugee status as a quote-unquote protective cloak for malign activities, as if someone who faced that kind of persecution would turn around and say, actually, I want to help the Third Reich in this war. And so I think as a matter of, like, justice and recognition, like, that is a group where they have been long owed an apology. And hopefully bringing that apology forward will also, you know, get people who have large German-American constituencies onto this kind of bill, onto this kind of initiative to say, let's close out this law. Even when it's used for its intended purpose, it violates our contemporary notions of due process and equal protection.
Katherine Yon Ebright is counsel in the Brennan Center's Liberty and National Security Program, where she focuses on war powers and the constitutional separation of powers. She's been fretting about the Alien Enemies Act of 1798, while a lot of us, including me, were asleep at the switch. And I think this is a really useful maybe place to think about ways in which laws that have been used almost entirely to perpetuate injustice need to be wiped off the books, not just because they might do so again, but because they've done so cruelly in the past. Katherine, thank you so very, very much for being with us. It was unbelievably illuminating and kind of hair-raising to have you. Thank you.
Thanks.
That is all for this episode. Thank you so much for listening in. Thank you so much for your letters and questions and your comments. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus Podcast. Do join us on today's episode of Amicus Plus. Slate's very own Mark Joseph Stern and I will be back in the Amicus Plus members-only rumpus room to process some of the stuff we couldn't get to in the main show, including the near miss at the Georgia Supreme Court over vote counting there, and finally, the U.S. Supreme Court putting a date on the calendar for the trans healthcare arguments. We're going to talk about what that timing means and why it took such a very long time. You can subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and on Spotify, or visit slate.com/Amicus Plus to get access to our Amicus Plus bonus episodes wherever you may listen. The new episode is available for you to listen to right now, and we'll see you there. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus in 1 week.
Now you can get Cox Internet and One Unlimited mobile line for $80 a month, all with Wi-Fi equipment included and no annual contract. If only getting it all was always that easy. Like having a night out and getting a good night's sleep. Get it all with Cox. Get Cox Internet and One Unlimited mobile line for $80 a month. Visit cox.com/value. Limited time offer for new customers only. No annual contract means no minimum term agreement and no early termination fees. Additional restrictions apply.